Welcome everyone to today's Fireside Chat number 295. It's September the 25th, 2012. Our topic today is improving children's food access through school zoning bylaws. We have two presenters today, Suzie Pellerin, who is the director of the Quebec Coalition on Weight-Related Problems, and Marc-André LeChasseur, who is a lawyer specializing in municipal law. And we also have an opportunity to hear from several panelists, Michael McCandless, who's a lawyer out in Manitoba, Louis Carvello, who is a lawyer and registered professional planner out in BC, Hazel Christie, who is a registered professional planner also in BC, Olympia Panteliman as a registered professional planner in Alberta and an urbanist from Quebec, Howard Epstein, who is a lawyer, and he's in Nova Scotia. So great to have you all there.
Hello, everyone. So thank you for being here today. I'm really glad to see your interest in that matter. Today we will present a project that we start at the end of 2008 and finish in 2011. So it's going to be a quick review of 3 years of work with local communities, and also this project has been funded by Québec en Forme and FACT, and has been made with Réseau Québécois Villes et Villages en Santé and the Public Health Association of Quebec. But first, next slide. I will introduce you to Marc-André LeChasseur. So you have to know that when we developed the project, next slide please. When we developed the project, the fast food chain attacked us, and also some municipal NGO ordered some legal advice to say that we cannot regulate, fast food restaurants. And so we had to be really strong and to collaborate with people renowned as a leader in their field. So that's why, after calling in many lawyers' office in Montreal, everybody was suggesting Marc-André LeChasseur as our advisor. So we're really pleased that he accepted to take part to that project. And Marc-André is a lawyer, but also he published 3 books regarding urban and law, and also he's a teacher at the McGill University.
Thank you, Suzie.
Next slide. So let me introduce you to the panel. So today we made a rehearsal in French, I will say, but the English one will be quite interesting because we have a cross-Canada panel, so they will be able to tell us, if the pilot project as we made in Quebec is possible in their provinces. So you see, you will hear Michael, Louis, Olympia, Hazel, and Howard. The Quebec Coalition on Weight-Related Problem is it's an advocacy group, and we have more than 220 partners coming from many sectors: municipality, healthcare stakeholders, researchers, school boards, people in the physical activity. Next slide. And our objective is to convince decision makers to put in place some policies helping healthy eating and physical activity. So as I already saw comment coming from Bindai saying that it takes time to achieve the goal through policy. It is true, but when we change policy, it favors everyone, and it gives a clear signal. So that's what we want to do. Next slide. We were also involved with the next slide, please. With the Public Health Association of Quebec. So their mandate is to improve health, and they exist since 1943, so they are quite renowned, and we were really proud to be a partner with them. Next slide. So as you may know, obesity is a big problem, and in Quebec, we introduced school food policy in 2007. So this project came right after, because we were thinking that fast food restaurant near schools will give a hard time to those new school food policy. And it's confirmed because last spring the Education Ministry ordered an evaluation of that school food policy, and it's clear, we improved the meals served in schools, but in the comments they were able to write what is the main problem, during that introduction and since then. And they all mentioned that they have a lack of financial resources, but also they're really concerned about the competition made by fast food restaurants surrounding schools. Next slide. During that project, we've made a survey with the people, the children, mostly from high school, and they, of course, they go in fast food chain, and because it's really close from their schools. Next. So we think after that project that it is possible for municipal, they have jurisdiction on matters of land use planning. They have the power to impose urban planning by law for the general welfare of their population, and they can regulate fast food. Next slide. Okay, let's talk more about the project. So we made a call for proposal, and we choose 3 cities, but with 3 different profiles. So Baie-Saint-Paul is more rural, and they already have in place a regulation to ban fast food surrounding school, but they want to take profit of the expert involved in that project and having some support in communication, but also in urban planning and in law. In Gatineau, the project was different, and because they were concerned about families, and that's why they suggest. And it's a big town, so it was interesting to have them on board. But they have many schools, so that's quite a challenge because Gatineau is made by after fusion. So we have many profiles across the city. In Lavaltrie, it's a suburban. So with the different profile, and people coming from there, they're working mostly in Montreal, and they arrive late on night. And the problem was that the teenagers finishing school at 2:30 spend all the afternoon in fast food surrounding schools. Next slide. So the objective was to validate the urban and legal possibility. As I mentioned, we've been attacked by many people saying that it's not possible. And also to work on the political will, having a survey showing that populations support that, because politicians and decision makers are really concerned about public opinion. And that's why it takes a big part of the project. Next slide. In each not country, but cities, we create working committees involving business people, education people, health, public health people, Quebec en forme, and they work pretty hard during that time looking at regulation, but also, giving us the a reality check, I would say, and a local dimension to our reflection, and expressing that to our expert committee made with lawyers, planners, and researchers, and they advise us during all that process. Next Next slide. So first thing, we put together all the legal information, regulatory and urban information, and that Marc-André will present it to you. And we also made some scans, you know, what's the cartography surrounding school is there, because we had some data coming from the Public Health Institute saying that it's 15%, I think, of it's 37% of public schools in Quebec that are located within a 15 minutes walk or less from a fast food chain. But it shows during that cartographies that, you know, the Public Health Institute research only took into consideration the big chain, you know, the big M and the subway and things like this. But in the three cities, we saw many little independent pizza place, and they were not considered by the Public Health Institute. And also we've developed some proposals for the council, and some of them choose to go through with our proposal, and also the pros and cons, of course, of each proposal. Next slide. So when I was talking about the public support, we can see that in those three cities, the more that we've talked about the project, the more we've got some support coming from the population. Like in Gatineau, the mayor made a lot of radio show, TV show about the project, and we can see that there is a bigger support after only 1 year. And in Baie-Saint-Paul, the same thing. The mayor was pretty active in the media. But in Lavaltrie, there is only one paper, so maybe it explains why we didn't see, you know, an increase in the public support. Next slide. So we've developed a lot of knowledge during the project. I was talking before about the cartographies, but also some legal briefing, also urbanistic option, glossary, evaluation report, and a guide available on the web that you can access. I think it's on the CHNet. We also put the link. And if, like this morning, some people already send me an email, and we are able to send the glossary or anything that you want, because I'm not able today to present everything. Next slide. So as I mentioned, we made a scan of the international laws and helping us, you know, to develop our recommendation. So I will ask Marc-André right now to explain to you what we've found in our international scan.
Thank you, Suzie. Thank you. So hello, everyone. I got involved with Suzie on this matter. The first thing we did actually was to sort of define what the world was doing outside Quebec, basically, and outside Canada, to see if there was any regulation or any laws adopted to regulate or supervise, I would say, the offering in fast food. So we all know that that's a problem, and like a third of the adult population is obese, and about 50% maybe of the American children and adolescents are overweight. So obviously there's something going on. So our first instinct, I would say, was to go and see what was done in the U.S., because if they have most of the obese, they probably have solutions as well to counter the problem. So we looked deeply into what the bylaws were made of regarding this problem, and what we found out basically is that they had already jumped in with regard to zoning bylaws, which was not surprising in a way, because they sort of invented this obviously this way of dealing with property and public health. So we thoroughly looked, I would say, into the zoning bylaws adopted from 1979, which were the first one we found, until 2012, and dealing with the zoning of fast food restaurants, I would say. It's very interesting to see that none of these bylaws explicitly tie their zoning regulations to health concerns, and they have the unintended effect, I would say, of promoting public health. So that triggered something in our minds regarding the capability of cities in Canada to be able to adopt zoning regulations and tie them to the health concerns. So we crossed the ocean and went to see in England mostly what was being done, since they actually have a problem in England that is similar to the one they have in the U.S., which is that between 1994 and 1984 and 1994, I would say, the obesity rate among adults and the number of fast food restaurants, they roughly doubled during this period of time, which obviously triggered the problem we know in the U.S. and we know in Canada as well. So, and the British, they actually are the largest consumers of fast food in Western Europe and have the highest rate of obesity. So, all this to say that some regulations were also adopted by cities in UK, and basically London adopted in 2006 a very good example of what can be done. So we gathered these examples and tried to find a way that we could actually deal with this matter in Canada. Most of the provinces have similar planning laws, I would say, whether it's a Planning Act of Ontario or I think it's a Municipal Act or something like that in BC, and we have the Land Use Planning Act in Quebec, and they're all based on the same powers from the Constitution, being the property and civil rights. So by looking at the U.S. Example, we obviously came to the conclusion quite fast, because we know where their zoning powers come from, that they were dealing with this based on the police power, which is not the case in Canada. So we don't actually, we have this police power as a residual power in the Constitution, but the provinces don't have the right to adopt zoning bylaws or delegate the power to adopt zoning bylaws to city based on the police power. So we look basically at the place where the power is given to cities in Canada to come to the conclusion that we would have to base our planning interventions based on the standard property right power given to the province and delegated to the cities throughout various legislation, such as the Planning Act, as an example. So the exclusion of having the possibility to plan based on the police power sort of took away the possibility to directly link the zoning capability of the provinces to the health matter, and forced us in a way to deal with this problem based solely on our power to regulate the fast food offering based on planning per se. So we were actually surprised to see that the same orientation, as I said earlier, was adopted in the U.S., even though they have the right in their constitution to use health and public welfare as a basis for the exercise of their zoning powers. So, by looking into what we had gathered, we basically found that there was major orientations taken both in the UK and in the US dealing with the zoning of fast food restaurants. Many powers were exercised always in the same direction. The first ones were the performance standards that were created in order to basically limit the nuisance that could come out of having such restaurants. And the main concern with performance standards, which are, for the planners, it's an old way of dealing with industrial uses usually, was the circulation problem that could come out of having a fast food restaurant. So some criteria had to be met, and some points were given to an application for the issuance of a special permit for the opening eventually of a fast food restaurant. So those special permits were based on performance standards, and those standards were dealing with nuisance, as we know when we deal with industrial uses. almost, I would say, throughout the country, and that was a trend that was enforced, I would say, mostly in 1970s and 80s. That is a little bit less enforced now, but tends to come back with the conditional uses. So the first, where it all started in Massachusetts, I would say, based on the performance standards. Afterwards, some other type of zoning were developed, and I'm thinking about the special permits, which we may know here as conditional uses. It's a similar thing, basically. So these special permits were awarded to people who would file a demand, and they would their application would be received, and the permits would be issued based on the application of tests. And those tests would also include sometimes performance standards, but are most likely to use only standards that are dealing with strict norms, I would say, such as a distance between restaurants of a similar kind, and limit the number of restaurants in a zone, and criteria such as those ones. So those permits, those special permits and conditional uses are from afar the type of planning tool that is most used in North America for now, dealing with fast food offering. There's obviously also what we found with the prohibition, the mere prohibition that we all know as planners or lawyers using, dealing with planning, that the prohibition of a use in a zone is the most efficient way of prohibiting, obviously, something from the moment that we don't prohibit the use throughout the territory of the city as a whole, which is illegal or ultra-virus, as we say. So, performance standards, prohibition under the normal zoning, the standard zoning that we know since the 1920, I would say, the conditional use permit, the quotas, and the distance between two similar restaurants within a zone were basically the examples that we found out that were used to adopt regulations based on, to ban basically or limit fast food in U.S. and London in Great Britain. Just so to specify this, in the Waltham Forest Borough in London, they actually have they use a tool that is quite similar to the first one put in force in Massachusetts, in Concord in Massachusetts 30 years ago, which is the use of performance standards dealing with the protection of housing, the road safety, the opening hours, others, dealing with the waste coming from the activity, and all this. The level of crime also is involved in the assessment of the special permit required in the Waltham Forest Borough in London since 2006. So that's very interesting. So I think I maybe time to change slide now, I guess. Let's go to 25. Thank you. Let's go to 26. Thank you so much. Okay. So now that we had gathered the basic information dealing with how the U.S. do and how the UK does adopt bylaws, we were faced with the constitutional powers, I would say, the police power and the commercial clause that are included in the protection given to citizens in the U.S. Constitution. Because as you know, there's the commercial activities are protected in the U.S., so the local authorities have to be careful when they adopt bylaws. The same thing with the takings clause in the U.S. Constitution, which prohibit local government to adopt norms that take away the right of ownership or limit this right so much that it is tantamount to a taking away of the right of ownership. So they have to be careful with this in the U.S. We don't have to be careful with the same things here in Canada, but we have to be careful with making sure that our bylaws are valid under the property and civil rights in Canada. So most of the examples gathered in the U.S. and that can be used in Canada show that the bylaws are trying to figure out what is a fast food restaurant. Are we talking about the menu? Are we talking about hot dogs and all this? Or we're talking about the type of building that where that use will be situated. So they developed a real gymnastic around the concept of a fast food restaurant, which they call in California a formula restaurant. So these fast food restaurants are defined in all zoning bylaws in similar ways, and they're not really talking about food, which might be surprising in the U.S. because we know that they're leaning towards that direction, I would say. But they're talking mostly about having a drive-through, having, trying to ban drive-through restaurants, basically, or formula restaurants that are like McDonald's restaurants, basically, or which are franchise. So they focus also on the aesthetic zoning regulation to lessen street congestion and maintain, I would say, the aesthetic qualities of the community. So they're heading towards more of a form-based type of planning, I would say, strongly oriented towards performance standards and traffic study, as an example. So they're not talking about menus, but they're talking about drive-through. They're talking about people standing in line before a plastic counter before having their food. They're really talking and defining what a fast food restaurant's based on the type of amenities. As for, if you want good examples of what I'm talking about, there's many examples in the U.S., but there's two really good examples that you might want to look into. There's some examples in Ontario that are worth mentioning. In New York as an example since 1993, but there's a good one in Minnesota. Yes, there's something good in Minnesota. It's, just give me a second, was adopted in 2008 at Arden Hills. They have a very good, very interesting prohibiting kind of restaurants there, not kind of restaurant, but kind of zoning there, that include, I would say, almost all of the above, dealing with standards, prohibition, quotas, distance, and all this. So Arden Hills, Minnesota, and there's also the Waltham Forest Borough in London, which are two very good examples of what can be achieved. Okay, there's an example, a very recent one in Tofino in BC in 2010, which also is interesting because it's prohibiting franchise restaurants in the city, to what I know, and San Francisco, also copying BC in some extent, had good bylaws also in 2004 dealing with the commercial offer for fast foods in some district of San Francisco. So, all this to say that in Canada, we have to orient our interventions based on the property and civil rights. So we don't talk about the menu, we talk about using a piece of land, building something on it, and having a use inside the building. This power is given to us in Quebec under Section 113 of the Act respecting land use planning and development. There's also a similar power, obviously, in all the legislation on planning in Canada. Maybe it's different in Newfoundland because I think it's a different type of zoning basis. More of a UK type of zoning powers. But all this to say that under this zoning, under this Section 113, we are entitled, as others are also, to divide the territory of the city into zones and to provide for each of these zones what kind of buildings and what kind of uses are actually authorized there. So there's no question whatsoever that we can use the traditional zoning power to allow for or to prohibit commercial use of the type of a restaurant, as an example, in a zone, whether the zone is located around a school, around an hospital, or somewhere else in the area of the city. So the question is can be answered by this very simply. Can we zone fast food restaurant in a city? The answer is yes. If we define what is a fast food restaurant, we define it by the type of amenities that compose that type of use. We are able to define it. It's a discrimination, but as you know, zoning is all about discrimination. So there's a way to do it, and we also are able, obviously, to allow in different zones the kind of classification that we want. So we can strictly go with residential, strictly go with commercial, strictly go with industrial as an example. So that's a possibility, which is a very straightforward one, I would say. Please change slide that if you will. So all this to say that if we merge this traditional power with what we have here, it's Municipal Powers Act. It's copied on what Alberta did in its new, I think it's a new municipal code, by adopting the very modern way of drafting laws and bylaws, which was validated in taxi drivers by the Supreme Court in mid-2005 or 6, I think. These acts provide for general power given to city to adopt bylaws based on peace, order, and good government for the general welfare of the population. That is not exactly the power to adopt laws or bylaws for the health of the population. But it's a residual power that can be mixed with other powers, and that can actually support an exercise that incidentally triggers the question of, is that adopted for the health of the population? The Supreme Court in 2001 said in pretext that regulating pesticides and environment issues per se is for safety and security of the population, but that is for now an objective that is valuable for national values. So the health now we learn its national value, just like it was, I think, in 1926 when the first zoning bylaws were challenged in the Supreme Court of U.S. in Euclid against Amber Realty. So we learned that the health is something that may be taken into consideration when dealing with this. I will ask you to change slide as well. So the spray tech issue, that's the first very interesting case law on this. Can you go to the next one, please? So the Supreme Court said in many cases dealing with environment per se, that this issue is a national issue, and I think health comes close to this. So in order to defend a zoning bylaw that discriminate against, I would say, fast food restaurants, we need the fast food tools, we need the zoning tools per se. We also need to get some kind of a support from the case law telling us, I think, that there's a basis for that in our jurisprudence, and the Supreme Court is keen on insisting now since 2000 on the fact that environment and health are part of our national values, and that it's normal for cities to take care of their citizens. So that is supportive, I would say, of our position that we can do it under zoning, not based on per se the police power to regulate health, but our power to regulate property and civil rights in the province, which might also triggers the concern about health in our municipalities. Slide, please. So in order to do so, there's different type of ways. We have the grid showing the top-down zoning here, starting with the policies from the government to the planners, to the planning bylaws at the bottom. I will ask you to change slide as well. We'll go with the options that we have. So since we have a top-down zoning policy, it's actually interesting to see if the government will eventually get active in this to provide the policies that cities on a local standpoint may intervene directly towards health to deal with and adopt bylaws dealing with this. So the tools we have, and if we would copy, basically, get inspired by what the US and UK did, we can actually do the same thing, but still we have to do it based on the property and civil rights. The good thing about the US is that they were shy to use their power to deal with health in the first place, and they used their powers as if they were living in Canada, actually, based on property and civil rights, which is quite rare, actually, as you will all agree. So we might get inspired by what they did. So the tools would be that we get a full prohibition in the first place, not on the whole of the territory of the city because that's illegal, but unless law says otherwise, but it's illegal in Quebec. So fast food restaurants have to be allowed somewhere. So the good thing is that it doesn't have to be physically really feasible to have a restaurant here because our case law tells us that cities don't have to conduct studies before zoning, which might be different in other provinces. The thing is that we can prohibit fast food restaurants, but not throughout the city. The good thing is that by doing it, we may easily prohibit restaurants of fast food nature around schools and around hospitals that cannot, in my view, be questioned. It's like prohibiting a nuclear plant, adjoining a school. Nobody will question that. It's pure power, pure zoning power. The conditional use bylaw also is something interesting, what they call the special use permit in the U.S. So we may use this tool to study all applications based on standards and criteria on a case-by-case situation. That is a tool that is more and more used in North America, and that is because it's more flexible, I would say. What we call the quotas or the distance are very interesting as well. So in a zone, we can limit the number of restaurants, or we can require a minimum distance between two restaurants of the same nature. That is usually provided in a conditional use bylaw or in the standard zoning bylaw as minimal norms that will apply. And I don't think that nobody will question the possibility of having quotas or distance between same type restaurants if we are able to clearly define what is a fast food restaurant. We might also use a maximum area in a building for that type of use, or provide that that type of use can only be accessible or permitted in a building where there's other type of commercial activities or offices, as an example, which will limit the standalone type restaurants to be erected. Next slide, please. The discrimination of land use, that's the basis of the zoning in U.S. and in Canada. We discriminate, we authorize some things here when we prohibit others there. That's the basis of zoning, and that was validated in Canada in 1950 in the Sonal case, and in 1926 in the Euclid case in the U.S. So those are I would say, the basic rules that we apply. We have to be careful not to discriminate against persons, because obviously that's people zoning, which is absolutely not possible, because we're zoning land, not people per se, nor menus, I would say. And it's not possible to ban a fast food chain based on the fact that it's called McDonald's, an example. That would be, you will all agree, that would be silly. But we can use the amenities or the components of a use like drive-through to prohibit the excess of drive-through and prohibit also the service of food at the counter, as an example. Those are the type of norms that are used to define what a fast food restaurant is, and there's all based on that type of definition to actually identify what is a formula restaurant or a fast food restaurant. So those are usually franchise, but there may also be standalone type of restaurants with specific amenities or very low type of very minimal area floor. So those are criteria that are taken into account in the definitions. And once those definitions are very well drafted, afterwards you are able to use the tool and lessen the possibilities of having your bylaws contested based on a discrimination in the commercial discrimination, I would say.
Thank you. And we have a lot of comments, so just to let you know that I put some definition based on our glossary developed by each city. So if you want to send me an email, I can send everything to you. And also, I saw a comment regarding, the case that we can put out of business small stores, but we're not talking here about putting people out of business. The one already in business will stay. This solution is more for the neighborhood in development, for example, or if you build a new school, just to have this in mind. So next slide, please. So we will ask now to Michael to react.
Hi, I'm Michael McCandless. I'm supposed to give you a short introduction. I'm a lawyer specializing in planning and municipal law for quite a long time, based in Winnipeg. I also do a lot of consulting work with planning consulting firms, especially overseas in the last 15 years. A little bit of context, and Marc-André described a typical Canadian planning legislation scheme, and Manitoba's is quite typical. We have provincial land use policies adopted by regulation of the cabinet. We have development plans for municipalities that they're approved by the province. We have zoning bylaws that must be consistent in implementing development plans. We also have much experience with conditional uses. In Manitoba, we have one regime for the city of Winnipeg and another for the rest of the province. Winnipeg is really the only city we have. Winnipeg has its own special legislation, which covers all of municipal administration and powers, plus a chapter on planning and zoning. The rest of the province is governed by a municipal act and a planning act. For today's purposes, there are really no differences. In Manitoba, municipal purposes are stated very broadly. In Winnipeg, promote and maintain the health, safety, and welfare of the inhabitants. Bylaw powers include health and well-being. Similar under the Planning Act, governing the rest of the province. So all of the regulatory tools suggested by Marc-André are available here. Prohibition of main uses, relative distances, fixing quotas, and conditional uses. At present, there is nothing in our provincial land use policies or our development plans or zoning bylaws that come close to the concept of food environment near schools. Health aspects in our existing regimes have more to do with public safety from a health point of view. Nothing about the nature of restaurants or the food that they serve. The only thing we have which is relevant to the discussion today is that it's quite common in Manitoba for drive-throughs to be conditional uses, and the criteria that are applied to that have nothing to do with the nature of the establishment. They have to do with traffic concerns and nuisance to the neighborhood, that sort of thing. Though, of course, in a public hearing on a conditional use, people will complain about the restaurant itself. We do have a little bit of experience in regulating or prohibiting uses within distances of schools, and that is in the Winnipeg zoning bylaw. Sex shops and adult entertainment establishments have to be at least 1,000 feet from schools. So those are the only things that are even close to what we're talking about. The big question, though, is can in Manitoba the food environment near schools be regulated as proposed? I would have to say yes, with a few reservations that I will mention. To implement it in Manitoba, I think because of the absence of any reference in our policy documents to this kind of concern, I think that the development plans should be specific on policies for healthy environments. And it would be good if our provincial land use policies had the same kind of policies in them. But having said that, even without a policy basis, I think that in just say new suburban development, you can separate uses and treat fast food restaurants differently in the zoning map and the text for the zoning for the area. Our practice here is that all new development in suburban areas requires a rezoning. We leave land zoned agricultural until somebody comes along with a proposal, so that there can be a zoning which is customized to to the location and the right kind of spatial separation being done. You could have a zoning agreement that the developer signs, which is in more detail and could deal with fast food restaurants. That's that kind of zoning agreement is registered against the title. Reservations. Reservation is the definition of the fast food restaurant based on the physical characteristics rather than the menu. When really what we're getting at is the menu, but we have to define fast food restaurants without reference to it. I'm not sure if that allows the basis of a legal claim, but it does open the proposal to criticism on a factual basis. You know, the distinction between fast food and other food on its contribution to obesity and health. Another factor is its minimal effect in established neighborhoods. The concept of legal non-conforming right makes it maybe not have the impact that's needed in established neighborhoods. Even though these are probably not legal objections, I think they might have a chilling effect on politicians, local politicians. The controversy, the fight with the restaurant industry, the fact that the distinction between fast food restaurants and others is not focused on the health characteristics or nutritional value of the food, but on the physical characteristics. I think that might make it hard for politicians to stick their necks out and go with it. I think if it was going to be done, the conditional use technique is sounder, where the criteria could be established. My experience is that politicians don't like public hearings very much, and if they thought that this kind of proposal was going to lead to a lot of applications with controversial public hearings when new restaurants are proposed, another reason they might want to shy away from it. Finally, in Manitoba, our general municipal powers, bylaw powers, cover health and well-being, and a lot can be done outside of zoning by bylaws that could get into health and nutrition and menus and those kinds of things, and I think would be easier for politicians to use. And we don't have to use zoning, even for spatial characteristics in this kind of regulation, and that's been defended or approved in the Manitoba Court of Appeal in regulation of livestock production, where bylaws were passed under the Municipal Act to prevent nuisances rather than under the Planning Act. My time is up, and I'm interested in hearing what everybody else has to say. Thank you.
Good afternoon, everybody. Can you hear me okay? I really want to say that I'm quite impressed with everything I've heard so far, and a lot of the comments that are coming in on the chat window. I think you have an excellent handle on the issues, both the opportunities and the constraints here. I particularly, I'm a lawyer, was a planner, worked the first part of my career for property owners and developers, including fast food chain. And I first came to this issue because we were trying to, we were being faced with local governments banning drive-throughs. So that's the land use issue that I came to. For the last 8.5 years, I've worked for local governments across BC, including small towns. and I particularly like that comment from small town in Wolfville, Nova Scotia, where the possible effects of this tool. Bottom line is, I was asked to research this issue on a BC perspective. I am allowed to share my knowledge without waiving privilege over the opinion or identifying my client, so that we get the legal niceties out of the way. Statutory authority currently exists for local governments in British Columbia to implement measures in support of school healthy food zones through planning and land use management tools, including the creation of areas around schools where land use is deemed to be incompatible or excluded. However, there are limitations, and as you've heard, the focus must be on land use rather than on food products or ingredients. Marc-André mentioned minimum distance separation as one of the tools that is used, and there's legislation that permits that specifically, but in BC we do not have that specifically referenced in our land use legislation. The other comment was made about existing. So existing incompatible uses are protected by law, and anticipated regulation may result in increased undesirable uses as those that would be restricted seek to establish themselves first to obtain this non-conforming use protection. So I see there's an issue there between the race to the swift, I call it, versus the long-term new town planning or suburban planning. And so on to, oh good, I was just about to ask you to switch the slide to 53. So 53, that slide identifies that local government activities in relation to public health is not independent. That requires cooperation from the province. And I've added this slide for context. In BC, our public health powers for local government require what's called concurrent authority, so we have to have a regulation, agreement, or ministerial approval. I did not look into the public health powers. I was asked specifically to deal with the land use powers. And so that's what I'm looking at in terms of opportunities and constraints. So on to the next slide. So our land use powers in BC are primarily in the Local Government Act. Again, as Michael mentioned, with Winnipeg Charter, we have the Vancouver Charter, which governs Vancouver. But for the purposes, I'm going to deal with the rest of the province. The differences aren't huge. So for the rest of the province, 903 sets out our zoning power. And we can divide into zones, and we can deal with land use, and it includes the power to outright prohibit. And on to the next slide. And so that slide shows subsection 3, which identifies where we can discriminate. Discrimination is usually a bad word. In the land use world, there's authorized forms of discrimination. We can discriminate along zones, we can discriminate by uses, we can discriminate by locations, a few other things not particularly relevant to today's discussion. So I agree with the earlier comments that we cannot discriminate by menu or ingredients or store, restaurant, branding. And I made the comment about minimum separation distance powers, which is mostly a caveat about the technique that can be used. So my last slide is some big picture considerations here. We have, in BC, our zoning bylaws must be consistent with our official community plans. Our official community plans have greater consultation requirements in terms of public input. And so in terms of the short-term regulation attempt, we have non-conforming use protection in British Columbia, and what the courts have developed a commitment to use concept. So as long as you have an unequivocal commitment to use, that's deemed equivalent to actually having already established the use. So in some cases, the attempt to do this could create a race to the swift mentality, where those uses that would be banned seek to establish themselves more quicker than they may have otherwise attempted to seek to. That's in a pre-existing condition. I totally see and agree with Michael's comments about if you're rezoning in greenfield scenarios, that you've got a clean slate there to establish the land use patterns as you do so. my last comment is a healthy school zone in this sense is more than just about food. And local governments investigating this might well consider some of the other incompatible uses they might want to also limit the location to schools, thereby, in a sense, deflecting away from the potential discrimination arguments that you're targeting specifically fast foods, and also look at the approach a little bit more holistically. But in the end, this is a blunt tool. You would be casting the net. To be effective legally, you would probably have to cast the net a little bit more broader than you would otherwise want to. So to eliminate the fast food chain, you're probably capturing other restaurants that are perhaps more innocuous. To eliminate the 7-Eleven, you're also probably catching that local organic grocery store. Now, there are certainly some fine lines to draw between them, but the point is we have to do it on a land use issue, not user.
Hi, I'm Hazel Christie, a professional planner working in the interior of BC. I'm calling in from Kelowna this morning, and I've asked, just to make some comments from a municipal perspective on the question of zoning around schools. In my 30-year career, I have worked for a lot of local governments on issues such as zoning and community planning. And I certainly concur with what all our legal experts have said about zoning being a control of land use and siting. If we could go to the next slide, please. And, zoning tends to deal with the tangible issues such as how high, how many people are employed, what are the parking spaces, in general terms, what is the use that is operating here? Is it retail? Is it residential, et cetera? And the definition of use becomes very, very important. And we've heard discussion of defining fast food restaurants, drive-through restaurants where you can, tangibly measure the characteristics of the particular use you're trying to define. Formula restaurants where you can say they have a consistent or a standardized menu, they have a standardized decor, etc., all things that are tangible. But of course we live in the real world where things are not black or white, and we get into the shades of gray. A convenience store that also sells takeaway fast foods or chips and pop. A grocery store where you would do your weekly grocery shopping, but yet it also sells elements that you would find in a fast food restaurant. So there's, it's hard to be as specific as you need in this question. And as we've heard, you can't go into the menus or the product offerings. You can't talk about trans fats or pop, etc. So I guess you really need to consider what problem are you trying to solve in your definition. And if we could go to the next slide, please. Some of the points you want to consider in discussing schools are what is the type of school. So, for example, elementary or middle school or high school, and correspondingly the size and location. So, for example, your elementary schools tend to be smaller. They tend to be within residential areas. You might, there may not be any commercial land use within a significant distance of that elementary school. On the other hand, a high school tends to be regional, and just because of the size and the traffic it generates, it may well be located on an arterial road. It may well be adjacent to or even within a commercial or an industrial area. And, certainly a local example of a regional high school is that it's right next to a commercial area, and the nearest commercial use is actually a grocery store, an IGA grocery store. And the students can walk there very easily and buy all kinds of unhealthy things as well as the healthy things that are on offer at the grocery store. Next slide, please. Some of the other issues within the school itself, for example, relate to student and parent choices. So what you see up on the screen is an example of the hot lunch program for an elementary school near me. And that is where the Parents Advisory Group puts on a hot lunch once a month. And they do this as a fundraiser to support library or playground equipment. And what you can see is, you know, half of the offerings are from local, Wooden Nickel and Shantana's, but the other half are Little Caesars and Tim Hortons, which are definitely franchised and most likely offering the type of fast food that we've been talking about. So, you know, your zoning can do a lot of things, but it can't necessarily control student and parent choices. And, you know, in the little picture on that slide, you see things like Lunchables or the juice that isn't juice, it's more sugar water. And these are things you can buy in a grocery store that tend to show up in people's lunches. So it's not as simple as just zoning or distance. And in fact, in a high school where kids have access to vehicles, they can drive beyond your restrictive distance to the fast food restaurant. Next slide, please. So in terms of barriers to success of a strict zoning definition, I would say that, yes, there is the difficulty of land use definition, which we've heard discussed, as well, the locational attributes of the school. Is it in a residential area? Is it in a commercial area? It'll be a lot more difficult to control if it is in or adjacent to a commercial area. As well, you know, student-parent acceptance. What choices are people actually making? And lastly, enforcement. Within a zoning bylaw, you need to be very, very specific in terms of your definitions and your criteria, because that will help you more easily be able to enforce whatever rule you've written. Next slide, please. So just in terms of this whole zoning adjacent to schools question, my suggestion would be, of course, to be precise in your definitions, but also to consider other congruent goals that the municipality might have. For example, a small town may wish to preserve the architectural integrity of its downtown, or it may wish to encourage pedestrian viability within a commercial area. And these congruent goals would contribute to the restriction of fast foods or formulas or drive-thrus. Another point, you really need to work with the school district and combine this initiative with education of parents and students. You know, many students go to school with healthy lunches, and they put them in the garbage, they swap them away, they run out to McDonald's. And so, you know, it's not necessarily just a zoning question. And, you know, lastly, I guess my underlying point is to realize that this is just one facet of a multifaceted issue. And zoning around schools is certainly a very useful tool, a helpful tool, but is not the only tool that we need to use to deal with this complex issue. And that concludes my comments.
Thank you. Good afternoon to everybody, and I will start to introduce myself. I'm a registered professional planner, or town planner, how we used to call in Alberta, and urbanist in Quebec. I'm a member of the National Affairs Advisory Committee with the Canadian Institute of Planners, and vice chair of the Healthy Communities Subcommittee with the Canadian Institute of Planners. I'm also a member on the Green Municipal Fund Peer Review Committee with the Federation of Canadian Municipalities, and on the Healthy Communities representing Alberta and Quebec. Also work with the City Region Studies Center, University of Alberta on the Events Committee and class for planning speakers, and do work with Municipal Affairs Government of Alberta as a Senior Planning Advisor. Today, I will continue the overview on how the legislative framework allows for changing the land use or providing for the land use in Alberta. And as we've had an introduction earlier in Quebec about how the Planning Act provides for every jurisdiction in Alberta, the first Planning Act in 1913 was passed, and since then lots of change has happened. In 1994, we've got the planning section transferred to the Municipal Government Act, the larger body that provides for municipal powers. And we've heard how land use bylaw is an instrument, a more technical instrument to deal with defining the use, defining the density, defining the separations if there is a nuisance. As you can see in slide there, several the Municipal Government Act that provides for how we deal with the land use bylaw. Important here is that the land use bylaw has to comply with the Municipal Development Plan, which is an overarching body for a statutory plan that urban planners and municipal decision makers deal with. And public consultation for writing, approving, and changing a land use is a must. Next slide, please. In particular, within the provisions of the Municipal Government Act, there is a requirement for collaboration and recognition of the provincial interest. This will guide local governments as to how their land use bylaw is being conceived. In particular, addressing school and health, there are provisions under the subdivision regulations and land education, mainly for providing for facilities, and land use policies asks for consistency and collaboration within health authorities. We also have a link within the regional plans which would have broad objectives for health, vibrant, and sustainable communities. Next slide, please. In other words, we have mainly three gender of stakeholders. At the provincial level, municipal affairs that would deal with Municipal Government Act and provisions and advise on how to municipalities, the land use policies that would provide the statement and principle on how to deal with land use bylaws and healthy communities. Ministry of Health that would deal with health authorities and school boards. They do have their internal policies, and school authorities are different from location to location. At the local level, municipalities and community leagues and associations, they would meet together and form green committees and specific committees to deal with healthy communities. Other stakeholders, major stakeholders that would provide evidence and examples as we do join all today in this webinar are Heart and Stroke Foundation, Public Health Agency of Canada, professional associations like CIP and others. Next slide, please. In other words, those three stakeholders, major stakeholders that I mentioned earlier, they do provide guidelines to municipalities and community associations on how to deal with. I'll give you briefly a few examples. In our ministry, there is a municipal sustainability initiative that provide advice and funding on how to develop instruments specific dealing with land use. Municipal excellence is a collection and a compilation of database of land use bylaws, guidelines, examples that other municipalities in the province do have and shared with the whole province. Other initiatives under Health Department do have guidelines on Active Alberta, aging in place, healthy communities, how to approach, how to work together, how to build a consensus around these elements. And, of course, health and planning partnerships, like we do have today, Canadian Institute of Planners, Heart and Stroke Foundation, and the rest of the team working together to provide example and advice on healthy communities. Thank you very much.
It's Howard Epstein in Halifax. I'm a lawyer here. I teach land use planning law at Dalhousie University's law school. I also served 2 terms as a city councillor on Halifax City Council. So I want to start off by saying that although I think this probably could be approached as a legal question, I'm far from convinced that this is really, in its essence, a legal problem. It seems to me that there are many alternatives, some of which we've heard, and even if you want to look at what municipalities themselves could do, or school boards, they could, of course, start with things like education, or by having exercise programs, or they could collect baseline data, or they could lead by example, as many school boards do, by offering healthy foods and so on. So it seems to me that it's not obvious that we have to rush to start treating this as a legal regulatory question. Second point, however, is that even if we did want to deal with it as a legal regulatory question, it's not clear which level of government, as between the municipalities and the province, we should call upon to or expect to take the lead on something like this. You will see in a moment that I believe that municipalities probably do have legal powers that they can exercise, but those legal powers, of course, always shelter under provincial powers, and the province might be the appropriate entity to really take the lead on legal regulation here, and that would depend on a complex political calculation as to which level of government is better suited to take the legal lead here. So, for example, if one wanted consistent across the province rules, it would be the province. If you wanted to have a joint regulation so that the province might set minimum standards, then leave it to municipalities to go beyond that. That's another possibility, but I think that's an open question. To move to the third point, the core question that we were asked is it possible for a municipality to actually legally do that? It seems to me that yes, the answer is pretty well uniform, likely across the country, that municipalities do have this legal power. Essentially, it's based in the idea of what zoning is, because land use is all about separation of incompatible uses and deciding what's allowable in one place and what's not allowable in other places. Obviously, there has to be a statutory basis for that. That's usually the Omnibus Power Clause, which talks about the health and general welfare of the population. And so long as there's no actual conflict with provincial or federal rule, then municipalities can not only begin to legislate about health matters, they can in fact go beyond what the standards are that fail provincially. I think we've seen a number of cases that have established that already. In fact, and I think I've heard my other legal colleagues say much the same, if I were to differ with them on this point at all, it's really that I think there might be being a little modest about how it is they understand the idea of what might be a fast food restaurant or what might trigger a municipality getting involved in this. I tend to think that the menu might be an appropriate basis for land use distinction. Think about gasoline stations. They have a particular zone of their own, and the point of distinction as a land use is the product they sell. So I think so long as there's something anchored in an official plan or a community plan, and there's a paper trail, municipalities probably could get involved here if it makes sense. A final legal point, however, is that for the most part, this is an irrelevant legal point, because most instances, non-conforming uses, or as they're called in Quebec, acquired rights, are going to mean that a municipality cannot, through zoning, shut down fast food restaurants, because if they exist, as they will throughout many built-up areas in towns and cities, you can't shut them down because of non-conforming use rights. So it seems to me that this is really going to apply only in greenfield areas. There are other legal alternatives, licensing, the idea of nuisance, perhaps some taxation issues, but I think that in the end, it's not clear to me. I would go back to my first point, which is that although it is something that municipalities could probably get involved with, it's not clear to me that this is a point best addressed through the law. Thank you.
I'm very happy to hear everybody talk about this issue, and I think we all share basically the same concerns dealing with the fact that zoning is one key element of this, or one element of this, but also a problem or a matter of education, I guess, that has to be taken into account by the society as a whole.